So do I go ahead and call it to order, Michelle?
Yes.
All right, so we're gonna call to order this HRB meeting tonight, Tuesday, April 18th, 2023 at 5:35 p.m. Awesome. Adoption of the agenda.
So moved.
Okay. First order of, second?
I'll second.
All right. First order of business
You need
is,
to take a
I'm
vote.
sorry.
You need to finish up with the vote. All in favor of
Oh, yeah,
the
all in
adoption.
favor?
Aye.
Perfect. Zoo, you got it recorded? It was unanimous. So first order of business tonight will be us selecting a pro temp that will now run the meeting in place of me. Any nominations? Oh, they nominated. We have a nomination for Mr. Forbes. I have two nominations for Mr. Forbes. Anyone else wants to nominate themselves? All right. All in favor, say aye.
Aye.
All right, unanimous. Mr. Forbes is now in your hands. You're here. So all you got to do now is on your sheet is go to the adoption of the minutes. So now you just go to old business and we'll call out the first case.
Do we need to approve the minutes?
Oh, yes,
Yes.
please. I'm sorry.
Mr. Chair,
Yes.
I move to approve the minutes from February 24th, 2023.
Okay, I have a motion to approve the minutes. Is there a second?
I'll go ahead and second.
All in favor?
Aye.
All opposed?
Carries.
It passes. All right, so now we see old business. There's an update on this case, right?
Yes, sir, there is, Mr. Pro Temp. So old business, Shakita Campbell, EO-E-202215. The board had asked us to go back and do some additional work on it. So we provided to you guys in your backup and previously by email a second supplemental to the investigative report. Would you like us to read it, Pro Temp?
Did anyone not get a chance to read it? The update?
I read it.
No, I don't think we need to read it.
All right, perfect. How does the board want to proceed?
Mr. Chair,
Yes.
I move to move forward in the direction that the Office of Equity and Inclusion had on this case.
Right, there's one motion to accept the office's judgment. Do I have a second?
I'll go ahead and second that. I went over it.
All in favor?
Aye.
All opposed? Great, I think we are accepting your judgment.
All right, perfect. That passed unanimous. So Pro Temp.
Oh, yes. Business discussion.
Tires is the first. Okay, that's it. For the Campbell case, can we see if anyone wants to speak, any public comment to the Campbell case?
Yeah, is there any public comment on the Campbell case?
I would just like to say I represented Ms. Campbell
Okay.
in this case. She
Can you
stands,
please come and give your name? Did they come here at the podium, Raul?
the podium's mic'd.
Will you go to the podium on the recording? And you give us your name for the record?
Hello, I'm Steve McNamara of Three Rivers Legal Services. I represented Shakita Campbell in this case. I understand the report. I would just like to say that Ms. Campbell stands by what we said in the complaint. So I just want that to be stated and noted that we do believe there was a denial of her rights due to source of income discrimination in this case. Thank you.
Thank you. All right, Mr. Director, I'm ready to move on to case EO-2022-17.
Thank you, Pro Tem. So tonight we're going to be discussing in case number EO-E-2022-17. Chair, the Equity and Inclusion Office has provided the members of the Human Rights Board a written report concerning a complaint of discrimination in EO-E-2022-17. We have processed the complaint as required by Chapter 8 of the City's Code. We are here today to report our findings as to whether reasonable cause exists to believe that an unlawful discriminatory practice has occurred in accordance with the City of Gainesville Code of Ordinance, Section 8-4A, Parent A, Parent 1. We are now ready to report the results of our findings concerning a complaint of discrimination in EO-E-2022-17.
Members of the board, thank you for your presence and participation. You have each received a copy of the final investigative report for complaint EO-E-2022-17 and have had time to review the findings. I will now summarize the findings as it relates to this case. Complainant alleged that respondent has discriminated against him based on his race, black, gender, male, and because he is regarded as being disabled. Respondent's position. Respondent denied discriminating against the complainant because of his race, gender, and because he is being regarded as an individual with a disability. Respondent stated that the complainant abandoned his position. Also, respondent stated that complainant later requested re-employment 3 months after he abandoned his job between November 2021 to February 2022. Summary of investigation findings. To establish a prima facie case for race and gender discrimination, complainant must show that 1, he is a member of a protected class, that he experienced an adverse employment action, and 3, that he was treated differently or less favorably than similarly situated individual not in its protected class under similar circumstances. The complainant is a member of multiple protected classes due to his race and gender. Therefore, the first element was met. Regarding the second element, complainant experienced an adverse employment action when he was placed on a do not hire list months after he resigned from his job. Therefore, the second element was met. Regarding the third element, complainant failed to establish he was treated differently based on race or gender. Rather, the evidence shows respondent rehired employees regardless of race or gender. In addition, complainant was performing below established standard at the time he resigned from his job. Witness confirmed complainant often left clients for several minutes and attended to personal issues such as getting food and watching football. Also, witness stated complainant would report late to work and meetings. Respondent provided evidence showing complainant had the lowest, quote, sales rate, end quote, for reporting period of October 14, 2021 and November 8, 2021. At the time of complainant's employment, respondent employed male and female employees for varying races. In March 2022, when seeking to rehire, complainant repeatedly called and came to the respondent's location demanding to talk to site manager, making staff uncomfortable. Due to this behavior, respondent chose not to rehire complainant. Currently, respondent employs individual within and outside complainant's protected class. Based on the totality of evidence or lack thereof, there is no evidence that the respondent's action were based on race or gender. Disability. To establish a prima facie case of discrimination based on being regarded as individual with a disability, complainant must show that 1, he has a physical impairment that substantially limits one or more major life activity, or has a record of such an impairment, or is regarded as having such an impairment. 2, he is qualified to perform the essential functions of the job, either with or without disability, or without reasonable accommodation. And 3, he suffered an adverse employment action because of that disability. The first element was met. Complainant did not provide the respondent with proof to show that respondent regarded the complainant as an individual with a disability. Excuse me, let me repeat that. The first element was not met. Complainant did not provide the respondent with proof to show that respondent regarded the complainant as individual with a disability. The complainant notified Mr. Caputo on November 8, 2021 via text message that he needed to go home due to mental issues. Complainant immediately left the job site. On November 10, 2021, complainant followed up with another text message to Ms. Caputo informing her that he was resigning from his position due to mental health issues. The investigation shows complainant never reported to work again or contacted the company until February 2022 when he requested reemployment. In seeking reemployment, no discriminatory comments were made as complainant was seeking rehire. Even if the complainant provided evidence to establish the first element, element 2 was not met for several reasons. Prior to complainant resigning, data and witnesses substantiated claims that complainant was not meeting performance standard. In addition, witness confirmed that complainant often left clients for several minutes and attended to personal issues such as watching football. Inasmuch as complainant was not performing to established standards and his consistent pestering of the respondent, he was placed on do not hire list. Also, witnesses stated that complainant would report late to work and meetings. Respondent provided proof showing complainant had the lowest sales rate for the reporting period of October 14, 2021 and November 8, 2021. Therefore, based on the foregoing, there is no reasonable cause to believe the respondent violated the City of Gainesville Code of Ordinance, Section 8-48A1.
As indicated in our written report, we have determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. If you do not believe that there is reasonable cause to believe that a discriminatory practice has occurred, the Equal Opportunity Director must dismiss this complaint. You also have the discretion to, by a 3/4 majority vote, order such further investigation as deemed necessary. Your decision should be based on the evidence of record. Chair, as required, we have provided the board with evidence concerning our investigation of complaint of discrimination in EO-E-2022-17. You must now decide based on that investigation.
Members of the board, you have had the opportunity to read the investigative report concerning complaint of discrimination EO-E-2022-17 and heard the summary of that report provided by the compliance investigator. What questions, if any, do you have concerning the report? Please direct board member questions to the pro tem.
No, I don't have any.
I guess my major question that I kind of have to ask is, and I guess you could refer this to someone from the Office of Equity and Inclusion, but was there any sort of request to ask the complainant of what that disability was beforehand? Because I think all I'm seeing is the respondent kind of providing what the complainant shared, but I don't know if the complainant defined what their disability was specifically.
Complainant never reported a prior incident of mental issues before November 8 and 10.
Okay, thank you. No further questions.
Is there anyone in the room who would like to speak on this case?
Any parties present? No.
All right, board, we are now ready to vote. We may only consider the evidence of record. The equal opportunity director has determined that there is not sufficient information that would lead an impartial observer to believe that discriminatory practice has occurred. You should vote aye if you agree that there is no reasonable cause to believe that a discriminatory practice has occurred. You should vote nay if you believe that further investigation is deemed necessary. The board shall then specify the areas of further investigation if, by a 3/4 majority vote, further investigation is deemed necessary.
I have a motion. I move to approve, to accept the deliberation by the Office of Equity and Inclusion on charge EO-E-2022-17.
All right, that is a motion to accept the office's decision. Do I have a second?
I'll go ahead and second that.
All right, all in favor? All opposed? All right, the board has voted that there is no reasonable cause to believe that a discriminatory practice has occurred.
The board has determined that there is no reasonable cause to believe that a discriminatory practice has occurred, and I shall dismiss the complaint. This concludes today's business as relates to the complaint of discrimination in EO-E-2022-17.
All right, I believe the board is now ready to discuss case EO-E-2022-31. Karen Indy.
Thank you. Pro Temp, the Equity and Inclusion Office has provided the members of the Human Rights Board a written report concerning complaint of discrimination in EO-E-2022-31. We have processed the complaints required by Chapter 8 of the City's Code. We are here today to report our findings as to whether reasonable cause exists to believe that an unlawful discriminatory practice has occurred in accordance with the City of Gainesville Code of Ordinance in Section A-48, A-1. We are now ready to report the results of our findings concerning the complaint of discrimination in EO-E-2022-31.
Members of the board, thank you again for your presence and participation. You have each received a copy of the final investigative report for complaint EO-E-2022-31 and have had time to review the findings. I will now summarize the finding as it relates to this case. Complainant's allegation. Complainant stated that she was forced to resign from her position due to her race. Complainant also stated that she was the only employee in the office who was assigned unfair working duties such as trading documents, sanitizing the office during COVID, and running personal errands. Respondent's position. Respondent stated complainant was not subjected to racial discrimination, nor was she forced to resign. Instead, complainant voluntarily quit on May 31st, 2022 when she was asked to outline processes before her effective date of resignation, June 3rd, 2022. Race. Summary of investigation finding. Race. To establish a prima facie case for race discrimination, complainant must show that 1, she is a member of a protected class, 2, she was performing at a satisfactory level, 3, she was subjected to a negative employment, personnel decision, or otherwise discipline. 4, she was subjected to negative personnel decision because of her race. Complainant is a member of a protected class based on her race, black. Therefore, the first element was met. Regarding the second element, there is no evidence complainant was not performing at a satisfactory level. Moreover, respondent did not assert that complainant had performance deficiencies. Therefore, it could be argued that the second element was met. Regarding the third element, complainant was subjected to a negative employment decision when the respondent assigned her to unfair working duties such as shredding documents and sanitizing and denied her time off requests. Respondent refuted these claims and asserted that all employees in the office were tasked with these responsibilities. Respondent also asserted that the white employees whose time off requests were approved were not similarly situated to the complainant as they were the company owners and all members of management. Both respondent and complainant confirmed that Ms. Thomas was given a pay raise after her 90-day probation. Also, complainant agreed that she was given a second pay raise for performing extra duties that were initially performed by Scott Brenton. The only witness in this case, Ted Canizales, stated that he did not experience nor witness any discriminatory treatment from the respondent against any minorities. This same witness experienced, quote, unfair business practices, end quote, relating to workers' compensation, but not discrimination. Complainant did not provide sufficient evidence to support a claim that respondent intentionally created an intolerable work atmosphere that forced her to quit involuntarily. Also, the complainant's additional information, rebuttal, provided during a one-on-one interview did not change the outcome of this investigation. Therefore, the third element was not met and the analysis ends. Therefore, based on the foregoing, there is no reasonable cause to believe that respondent violated the City of Gainesville Code of Ordinances, Section 8-4881.
As indicated in our written report, we have determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. If you do not believe that there is reasonable cause to believe that a discriminatory practice has occurred, the prosecuting director must dismiss the complaint. You also have the discretion to, by a 3/4 majority vote, order such further investigation as deemed necessary. Your decision should be based on the evidence of record. Chair, as required, we have provided the board with evidence concerning our investigation of complaining discrimination in EO-E-2022-31. You must now decide based on that investigation.
Members of the board, you have had the opportunity to read the investigative report concerning complaint of discrimination EO-E-2022-31 and heard the summary of that report provided by the compliance investigator. What questions, if any, do you have concerning the report? Any questions from board members should be directed to the pro tem. I had a question. When I read that Ms. Thomas received a second pay raise for performing extra duties that were initially performed by Scott Brenton, are these the duties that include sanitizing and shredding documents?
Yes, that will include all the duties. Sanitizing. I mean, it was the pay increase did not specify as to what duties it was assigned to.
So the pay increase is not related to the work of shredding documents?
Assigned to everything that she does.
And she never provided a job description for that position that the company would have provided.
The job duties included other duties, which includes
Sometimes
sometimes
employers will give.
sanitizing the office.
Okay. Thank you.
So
In that job description, it includes other duties, and the respondent said that included sanitizing the office. And she was not the only person that did that, even the manager. The owner did that while she was absent.
And so, do you mind sharing what type of business?
This is a car repair, import, continental import. They repair foreign cars, and mostly BMW German cars. So a lot of time the complainant was out. If you read some of the case file, she was scheduled off for 47 times. That was scheduled time off, and she was off, and that was approved. And that was one of the things that she complained about. But when she was off, the owner, one of the owners will substitute and perform some of her duties. But she was not similarly situated as the owner.
So you're saying the complainant requested 47 days off and was approved?
Yes.
Okay.
Thank you for that clarification.
Are there any other questions from the board?
No.
Are there any parties in the room who would like to speak on this case?
Yes, sorry, are you able to hear me?
Yeah, we can hear you.
Hi, my name is Connor Flynn. We've been representing the defendant in this matter, Continental Imports. I'd just like to briefly highlight a few items and respectfully request that the board adopt the conclusion of the investigation. Referencing the investigative report, I would reiterate that on page 3, there's the site for 47 different occasions where time off was requested, and each and every time that was approved. That on page 4, there's even noted the fact that a wedding, the complaint of the wedding took place at the location of the employer, that there was really, I'll just say that there's plenty of evidence in this investigative report to support a conclusion finding, and we respectfully submit that report should copy.
All right, thank you, Mr. Flynn. Are there any other parties who would like to speak for this case? All right, board, I think we're now ready to vote. I remind you that you may only consider the evidence of record. The Equal Opportunity Director has determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. You should vote aye if you agree that there is no reasonable cause to believe that a discriminatory practice has occurred, or you should vote nay if you believe that further investigation is deemed necessary. And if we do vote that way, the board shall specify the areas of further investigation if, by a 3/4 majority vote, we deem such further investigation is necessary.
Mr. Chair, I move to accept the Office of Equity Inclusion deliberation on EO-E-2022-31.
All right, there is a motion to agree with the finding there is no reasonable cause. Is there a second?
Second.
Second, just are there any opposed? All in favor?
Aye.
All right, I believe we have agreed with this. The board has voted that there is no reasonable cause to believe that a discriminatory practice has occurred.
The board has determined that there is no reasonable cause to believe that a discriminatory practice has occurred, and I shall dismiss the complaint. This concludes today's business as it relates to complaint of discrimination of EO-E-2022-31.
All right, I believe we are ready to move on to case EO-E-2022-36.
I'll be reading for the chair. Speaking for the Equal Opportunity Director. Chair, the Equity and Inclusion Office has provided the members of the Human Rights Board with a written report concerning complaint of discrimination EO-E-2022-32. We have processed the complaint as required by Chapter 8 of the city's code. We are here today to report our findings as to whether reasonable cause exists to believe that an unlawful discriminatory practice has occurred in accordance with the City of Gainesville Code of Ordinance 8-48 subsection F. We are now ready to report the results of our findings concerning complaint of discrimination EO-E-2022-32. Compliance investigators. Members of the board, thank you for your presence and participation. You have each received a copy of the final investigative report for the complaint EO-E-2022-32 and have had time to review the findings. I will now summarize the findings as it relates to this case. The complainant alleged that the respondent retaliated against him after the complainant reported the respondent's discriminatory actions to the respondent's complaint service department. The complainant alleged that the respondent unlawfully terminated the complainant after the complainant reserved a hotel room at one of the respondent's sister properties. The respondent denied discriminating and retaliating against the complainant. The respondent alleged that the complainant was terminated because he was insubordinate, belligerent, and disrespectful towards his supervisor, thus violating the respondent's code of conduct. Summary of investigation findings. In order for the complainant to succeed in his claims of retaliation, the investigation must establish the following. The complainant engaged in a protected activity. An adverse employment action occurred. There was a causal connection between the activity and the adverse action. The first element was met as complainant engaged in a protected activity, reporting alleged discrimination to Hilton Corporate on June 11, 2022. The second element was met as complainant was terminated by respondent on June 17, 2022. With regard to the third element, respondent stated complainant was terminated due to insubordination and a violation of their code of conduct. Based on the evidence provided, complainant and respondent were in agreement that it was not in complainant's best interest to stay at the Hampton Inn, Gainesville. Complainant's general manager helped him to secure a stay at another sister property. Complainant admitted that he booked another stay at Hampton Inn, Gainesville. This reservation was canceled by Hampton Inn, Gainesville, which is not controlled by the respondent. Complainant's general manager and a witness stated that complainant yelled at his general manager on the phone, despite the general manager stating that he was going to try to help him find another place to stay. Complainant continued to yell and accuse his general manager of conspiring against him. As a result of complainant rebooking the sister property after explicitly agreeing not to and yelling at his general manager on the phone, he was terminated. While complainant's protected activity and termination are in close proximity, complainant did not demonstrate that respondent's pro-offered reason for the termination was false, nor did complainant provide sufficient evidence to support retaliatory intent. Therefore, this element was not met. Based on the foregoing, there is no cause to believe the respondent violated the Code of Ordinance of Gainesville, Florida, Section 8-48, subsection L. As indicated in our written report, we have determined that there is not sufficient information that will lead an impartial observer to believe that discriminatory practice has occurred. If you do not believe that there is reasonable cause to believe that discriminatory practice has occurred, the Equal Opportunity Director must dismiss the complaint. You also have the discretion by a 3/4 majority vote to order such further investigation as deemed necessary. Your decision should be based on the evidence of record. Chair, as required, we have provided the board with evidence concerning our investigation of complaint of discrimination EO-E-2022-32. You must now make a determination based on that investigation.
Members of the board, you have had the opportunity to read the investigative report concerning complaint of discrimination EO-E-2022-32 and heard the summary of that report by the compliance investigator. What questions, if any, do you have concerning the report? Any questions from board members should be directed to the pro tem.
I guess my only question is do we know if the general manager and this witness had a relationship that would present a conflict of interest between the two? If they were closer, then more so in a more friendly manner, that would maybe lead the witness's testimony to be not as valid, or was there nothing that the Office of Equity Inclusion could find about that?
So the investigator that personally spoke with these witnesses is no longer with the office, but from the notes he provided, there was no indication that the witness and the general manager had any specific personal relationship other than just being co-workers.
Okay.
That's the only information we know about that.
Yeah, I just because the reason why I asked that question is because I wonder how the witness was able to overhear this conversation, if it was between the general manager and this person.
I think they were both coming back from lunch, riding in the same vehicle, and
Okay.
the witness overheard They didn't hear the exact verbiage and words that were exchanged between the complaint, of course, because he was on the other line, but they kind of heard the tone of voice that the complaint was using while on the phone with the manager.
Okay.
Can I ask something or say something?
There is going to be a moment for parties to comment in just a second.
Okay, guys, thank you.
What other questions does the board have?
Right now, I don't have any, but I'm still reviewing them again.
Yeah, me too. And so, was there a written or agreement that had to be signed by the petitioner to because I'm trying to see if I can find it, but I don't see if was there something written that says you cannot book at that location? Again, or was this kind of?
From our understanding, this was an employee discount where the employee received a specific rate for staying at a Hilton property. The first time that the complainant stayed at this particular property, there was an incident that occurred. There are various opinions as to what exactly occurred during this incident, but the manager at this sister location informed the general manager that they no longer wanted the complainant to stay at this particular property. And then it was agreed upon by the complainant and the general manager that he would not stay at this property based on what happened during the first time.
Okay,
The first incident.
was there a written agreement that said this? Because was this a conversation that was said please don't do this, and then it was then the petitioner would say yes, or was it they had to sign an agreement do not stay at this place? Because that's my only thing is if we're relying on the respondent's statement on this, I'm just confused, I guess you could say, whether or not it was something that was explicitly written down or not.
Well, are you saying what was written down was whether or not he should stay at the location?
Yes, was there some sort of record that the office obtained that said that he was not to be at that location?
Well, from what I understand, that this was a privilege, not a right.
Okay.
So it was a privilege as being an employee with the company that you can utilize this special rate, but it could be revoked if certain incidents occurred, if there was a violation of company policy or things of that nature, then that was a privilege that could be revoked. It wasn't a right that an employee had to utilize this discount.
Okay.
Did this Mr. Perez Hunt, did he inform the complainant that he was fired from his position because when he went in to log into his portal, he did not have access, was even aware of his
I think that was a later
demise?
conversation that he was made aware that he was terminated based on his insubordination.
Which was yelling at his
Yes.
supervisor, and we don't particularly know what was said.
No, we don't know the exact verbiage that was utilized. And for going back to this particular sister hotel, when it was agreed upon that he should not reside or book another stay at this particular hotel based on the first incident. So it was a combination of him rebooking the hotel and being insubordinate to the general manager.
So I've read the investigative report. The question that is confusing, or the situation is confusing for me because I understand he's an employee, but if he was booking rooms, then in that sense he was also sort of a customer. So
he was booking the room under the employee rate.
Under the employee rate, yes. But my question is the yelling that's occurring and the conversation of whether or not, insubordination. Right? Insubordination is a boss, employee sort of thing. That's not a manager of a hotel or lodging client. And so I'm kind of confused. When the insubordination, when the incident that's being called insubordination happened, was Mr. Rhodes on the clock, or was he not on the clock? Was he at work, or was he not at work?
I don't think he was at work. I think he was scheduled to work that day. And another reason that the respondent included was that he called out that day. He was the only cook scheduled for that day. So that was another reason and basis for them terminating his employment. But at that particular time, I don't think that he was on the clock when he was being insubordinate to his general manager.
So he wasn't on the clock during the yelling, and the call out is a call out, but they're saying he was terminated for like insubordinance and belligerence, which isn't what a call out is necessarily.
No, those are two separate things.
Okay.
He called out, from my understanding, he called out because he was in the process of trying to book another hotel, but he was scheduled to work. So he called out the same day that he was scheduled to work, and he was the only cook for that shift. The yelling occurred, I'm assuming, earlier that day before he called out. But it still was in relation to him yelling at his general manager.
So the complainant did work for Mr. Pierre?
Yeah.
Not the, okay, so he worked directly for that individual with that company?
Yeah.
Yeah, I think Pierre is the general manager.
And he was just staying at his sister's property, but utilizing the employee rate for the sister property.
So, and the alleged discrimination that the complainant is providing is that he was discriminated from accessing that hotel, correct? Or getting access into that facility.
Actually, the
No.
discrimination is, sorry.
Oh,
The discrimination is that they think there was retaliation because they submitted a complaint to the company complaint department. So my next question is, do we have information about what that complaint was?
Yeah, because
I haven't viewed the complaint, but I know it was based on him staying at the sister property. The first incident, there was a service dog involved. The complainant alleged that he was discriminated based on the service dog that he had with him at the hotel because the sister hotel was trying to charge him a service fee for the dog staying there. From my understanding, that service fee was eventually taken off of his account and he no longer had to pay the fee. But the discrimination is based around how he was treated in regards to him having a service dog or animal present with him at the sister hotel. And he reported that treatment that he received to the respondent's hotline, or complaint department.
So I think there's a paragraph on page 5 of the original investigative report that kind of talks about the quote-unquote insubordination incident that is the supposedly the step that led to the firing, right? Yeah, according to, which is, because otherwise it gets a little confusing as to who's going back and forth, but that seems to focus on this is what we're saying happened that led to
So, Sal,
and
I'm sorry, go on.
no, that's okay.
I usually don't make much comment here, but something just to keep in mind is when the complainant made his complaint on the hotline, that wasn't to the hotel itself or his general manager, and the termination took place just days later. So there's another element in retaliation claims that you actually have to have knowledge that someone made a discriminatory complaint. And so I don't know
So
if
you're
that
saying
occurred.
that it didn't occur until after?
Right.
Right. About this discrimination, but is he talking about it was retaliation for the discrimination at the first, what he claims was discrimination at the hotel, or was it?
Right, so the service dog discrimination is what he called the hotline about.
Okay.
That's not a call to the actual hotel, that's an
Right.
800 number for Hilton.
Okay.
The termination took place 3 days later. So that's where the fourth element of causal connection comes in, is they have to be close in time and proximity. If there's not overt discriminatory intent, which we don't have here, then it shifts to the, usually you just don't get causal connection at all anymore. But in this case, the other part that you have to look at within that fourth element is, did the general manager actually have any kind of knowledge that this phone call to a hotline was
And you're
been
saying
made?
he didn't?
I
the
don't know
general
that.
manager.
I'm just
Okay.
saying with 3 days
Interesting, right.
gap between,
He might-
it's
It's unlikely.
probably very unlikely.
Yeah, was there
Okay.
any sort of,
Okay.
was there any sort of notice that was put on record to the,
Thank
like,
you.
Thank you.
the respondent? Thank you, thank
I
you.
think the general manager did mention that he was aware of it.
Okay.
Okay.
After or before the termination was decided?
I'm not sure on that.
Okay.
Okay.
Are there any?
Well, so as Mrs. Martin was stating, that's the fourth element, or one of the elements for retaliation. The other element is that if the respondent provides a non-discriminatory legitimate reason for why they took the adverse action, and the complainant does not dispute that, then the respondent meets his burden. So in this case, the respondent provided a non-discriminatory reason that the reason for the adverse action was based on his insubordination and his calling out. And the complainant did not provide sufficient evidence to dispute those legitimate non-discriminatory reasons that the respondent provided.
So he didn't dispute it, is what you're saying?
Well, he didn't provide the evidence to
Dispute.
Yeah.
That was the reason.
And he called, like, when he called, like, had this, like, this confrontation via phone, correct? It was because of the fact that he wasn't granted to stay at that location, correct? I know there's a,
No,
am I missing?
We had a little accident over here for a second,
Oh,
sorry.
okay, gotcha. Yeah, no,
The chairs were not
I'm
functioning.
missing
I
something.
think the way that the conversation went, the tone of voice, I think the complainant was stating that his general manager was conspiring with the sister property and causing his reservation to be canceled. He wasn't happy that the reservation was canceled the way it was canceled because it didn't directly go through the complainant. The sister property manager canceled it on their own unilaterally and didn't consult with the complainant about it. But they informed the general manager that they were canceling a reservation based on what happened during the first incident. So I think he was kind of upset with how it was handled and it didn't go back through him. And he felt that the general manager was conspiring with the other sister property against him.
Board, are there any more questions? I would like to get to the, All right, if there are no more questions, I would like to invite parties related to this case to speak. Parties will have the floor for 3 minutes.
The plaintiff can, the respondent, the complainant can speak first in this case.
Okay, the
I
plaintiff
think
can-
there's 2 parties here.
The plaintiff can speak first if you're in the room.
I am.
All right, can we start a clock for 3 minutes? Thank you. You can speak.
Well, what actually happened was you guys, I think it was the guy in the white shirt over there. He was, basically the way he was reading the summary, it didn't sound correct to me at all. I filed a complaint when I was, it started, I was working at Hilton Garden and I asked for the discount because me and my girlfriend were moving out May 31st. We didn't re-sign our lease. And for the summer, I knew it was going to be about a month and a half, 2 months. We were going to need somewhere to stay. So since I was working with Hilton at the time, I was like, okay, perfect opportunity. And we began staying next door. It was Homewood Suites right there. And okay, just fast forward to when I get to Hampton Inn Suites, something went down, and I filed a complaint. And Hussein Paris, my general manager, he called me about it. And I didn't even know he knew about it, but I thought he was talking about something else, maybe something that I left out. We never had any issues at work. We never got any screaming matches like the paper says or whatever, anything. We didn't have anything against each other. We hadn't had any arguments or anything. But he called me that day, and we had like conversation about everything that was going on, and he's telling me that him and the manager of the other hotel are talking about it, and he basically, he doesn't insist, he doesn't tell me or demand me or anything. He just says maybe it would be a good idea if you don't go back because of what happened. But I didn't know just because I filed a complaint, I couldn't go back. The only reason I was going back to Hampton Inn is because it was in the southwest area of Gainesville, like maybe 5 minutes away from my job. And I packed it, we had to, in a 4-door Nissan, my dog, my 2 kids, me and my girlfriend, with all of our things that wasn't in storage. So each and every, like maybe every 3 days, we continue to have to pack this stuff back in there. So that was the reason I chose to go back there. So him saying I was being insubordinate by not listening to him, that's not true, because we never made an agreement of me not going back there. And him saying I was being belligerent by yelling at him, I never yelled at him. That first it was 2 conversations. The 50-minute conversation when I was living in Homewood Suites, and the second one I was at the laundromat with my girlfriend, and he called me to terminate me. As soon as he got on the phone, he was like, "Hey, Keenan, I think his name is Clayton Starks. He was the assistant manager. I got Mr. Clayton with me. Yeah, it's just too much going on. We have to terminate you. We made the choice to terminate you." And I was lost. I just hung up. There wasn't even a conversation from me, you know. And right after that, we booked into the Red Roof Inn because I had no more Hilton. Like, I couldn't get back into a Hilton.
Mr. Rhodes, I'm sorry, in the interest of fairness, your 3 minutes are up. We can motion to extend it by 1 minute, but then we have to offer 1 minute to the other party as well.
That's fine.
Mr. Chair, I move to extend the time for both the complainant and the petition, and the respondent to speak for 1 minute.
All right, can I get a second?
I say,
All in favor?
Aye.
All right, Mr. Rhodes, you have exactly 1 more minute on the clock.
Okay, we booked into Red Roof Inn, and that's when I called Kayla Birch. She was the investigator on my case when I first filed a complaint. I emailed her first, and then she said she would call me the following Friday at 9 a.m., and then that's when that's how we got here.
All right, thank you, Mr. Rhodes. All right, the respondent can also speak now at this time. Mr. Rhodes, could you mute yourself on Zoom for me?
Yes.
The respondent, if you're in the room, the respondent's party, you can speak, and you have 4 minutes on the clock if you choose to use it.
Thank you, Mr. Chair. My name is Ben Hong. I'm Vice President of Human Resources for McKibben Hospitality. So I want to start by saying that there's been some verbiage used around sister properties, and so the only property we manage in the city of Gainesville is not the Hampton Inn. It's actually the Hilton Garden Inn and the Homewood Suites on Archer Road. The Hampton Inn is a Hilton property, but not managed by us. As you may know, hotels are typically third-party managed or owner-operated and not necessarily owned and operated by the brands themselves. In this case, the individual, the complainant, as every employee of our company with Hilton, has a code of conduct when they use the employee rate. The employee rate talks about embodying Hilton values, upholding exceptional reputation of Hilton associates. Behaviors inconsistent with the program may result in loss of privileges and disciplinary action, including up to termination. In this case, Mr. Rhodes did book a stay with the Hampton Inn in the city of Gainesville. He came to wherever that complaint he may have made was filed through, as the board member at the end of the table suggested, was made through an 800 number to Hilton, unbeknownst to us. And as I'm reading this, I'm recognizing that that's where this complaint is being made to. We've never seen that complaint. However, the general manager of that Hampton Inn did make a phone call to Mr. Paris, our general manager at the Hilton Garden Inn, and stated that Mr. Rhodes was not welcome back because of his behavior and his actions at that hotel during his stay. That was relayed to him, and that was made known to him that he was not to make another reservation. In the course of time, he made another reservation, hence the follow-up call to him to explain to him that you were instructed not to make another reservation because of your behavior being inconsistent with the Hilton values and the Hilton Code of Conduct. I believe there was a question in the room whether there was discrimination as customer service or as an employee. While there was nothing that could have stopped him if he had paid the non-employee rate, he could have continued to use that hotel. but as he chose to use the Hilton employee rate, they are allowed to refuse service as a result of that due to the code of conduct that is signed at that time. So I state all that, and I do urge this board to, while maybe complex and seem confusing, I do urge this board to adopt the findings of the investigator, because it is clear that he was told not to go back, and shortly thereafter, he gets into a disagreement with the general manager and into a verbal disagreement and argument, hence the insubordination.
Thank you, Mr. Hahn. Wow.
Is there any way for us to deliberate on this matter before we vote? Mr. Chair, I move that we take 5 minutes to deliberate on the notes mentioned by both the complainant and respondent.
Yeah, we can talk. We don't have to.
Oh, we don't have to make a motion for. Okay.
We don't have to move into a vote.
All right, perfect. I just want to make sure. I'm just very confused. For me, I just don't understand, because I think we have to go back to the root of the matter, which is that there was a confrontation that occurred at this location that the complainant was staying at, and so I'm just confused as to like the validity of that complaint, because I don't, at least from what I'm reviewing, I didn't really see that complaint in the record.
Are you talking about the initial complaint
The
of
initial-
the complainant to the hotline?
No, not from the complaint of the hotline. From the location that he was staying at, they said that he was not welcome back. So I'm confused as to the reasoning behind why he was not welcome back. Was like, and obviously there was the service dog. I'm assuming it was dealing with the service dog. So,
Well, it was, I guess they're alleging that the complaint was using profanity and getting loud and being unruly with the employee staff at that other hotel. And like I stated, there's disagreement as to who was being rude with who. But because of that entire incident, that's why they didn't want him to come back.
okay. Is this like facility, or like did you ask if that facility had any like video or audio recording of like what occurred? Because I think that would help to clear up my concern.
Well, I don't think that's relevant to the retaliation claim that's before us today.
The complaint was about retaliation.
Yeah, that's totally separate.
So I think what I sort of want to know, to Ms. Martin's point, because it looks like there was almost a week between the complaint being filed and the termination. So when we go to this, I would like to ask for some additional investigation that includes if we can tell whether or not the general manager had that complaint sent from the Hilton overall, the umbrella company. Was it reasonable to assume that they had that complaint in mind before the termination occurred?
And I think to add to that, some of the timing on what we just heard in terms of who called who and when, because it's, and that relates to that, because the complainant just said that they called him at some point to say, don't go back, and it wasn't with the initial incident, but later.
Yeah. Well, but even to that point, there's a question of the complainant says it was not a mandate. It sounded more like a suggestion.
Right.
And the respondent is saying it was an order.
Yeah.
So I also think it'd be important to know if there's any sort of written word that says do not come back. Because if not,
Or even internal memo, because sometimes it's a contemporaneous internal memo. I told the employee not to return something.
So they did provide us with the code of conduct that the employees are required to follow.
And sign.
When they're engaging in these particular, they're utilizing this employee discount. I don't know the verbal words that were mentioned, but it's the discretion of the employee
is there no record of being told not to look at a property?
Yeah, that
wasn't
conversation was had between the complainant and the general manager.
But we're relying on the respondent's claim that was said.
No, the complainant also stated when
Yeah.
he was speaking that it was suggested to him that he not stay.
Suggested but not stated.
Stated, exactly, that's my.
Suggested but not ordered. If you suggest to me that I can't stay somewhere, or if you tell me maybe it's not a good idea that I stay somewhere, but then I stay somewhere, I don't expect to face repercussions for doing that.
Well, from the evidence that we have, they both agreed that it wasn't a good idea for him to stay there again.
Yeah.
Whether or not it was a suggestion or an order, they both came to a conclusion that it was not best for him to stay there again based on the first incident. So he agreed to the general manager's recommendation or suggestion. And then he went back and still booked another stay at that hotel.
Well, when the complainant just spoke, that's not what I heard.
I heard directly, I think it was something.
But he said, but he never, so what the complainant didn't say was that he agreed to what the general manager stated. But from the evidence that we have in the testimony that was taken when Mrs. Gray was over the case, he acknowledged that he agreed that he would not stay at this particular property.
That's kind of in that paragraph in 4 where he goes, so, yeah, you're allowed, once again, I felt as if you were against me during this process, and this basically confirms it, which means that he is confirming he knew about it. Right in the middle of that big paragraph at the top of 4.
Yeah, see, I don't know. Because right here I read, Mr. Parasant reminded complainant that they both agreed he would not stay at that location. But when the defendant spoke, he did not give me language that said that he agreed to that.
Well,
Yeah,
that's
but
what
it
he's
says,
saying now, but during
that's
the
what but I'm
investigation-
saying, right. So are these real, these quote, we're assuming that when it's quoted, that's what this, that this,
This
the
is
investigator actually wrote
This is
exactly what
information
the
that
person,
investigator collected
said.
during the time of the investigation. Now, whether the complainant is saying something different now after hearing what was said is completely different. This is the information that was gathered when he was spoken to by Mrs. Gray, which is, why she included it in the report. He can always,
Yeah, so I guess where I'm landing is it'd be a lot cleaner if there was some sort of written agreement that you would not come back to this location, or, we're saying that you have been banned from this location, can you sign here? And I don't know if that exists or not. I know we have to go off of this evidence of record. So what I'm saying is it'd be nice if the office could go back and see if any such agreement exists.
I agree, because, go
I'm
ahead.
sorry.
No, go ahead.
I feel it's important because if it was any civilian that was at a property, they would be issued a trespass warning or given some type of document saying, you need to stay away, you have been warned if you come back, police will be called or law enforcement will be called. And in this case, it's just verbal that we're going by.
yeah, but you don't get the, they've called police on you after they've given you verbal.
Exactly.
And then police
But
come,
we don't
but
have that in this case where, what we're talking about, we don't have anything in writing saying it's,
well,
As-
so
as-
what we have written, we have a text message
Yeah.
from the general manager to the complainant. In this text message, the general manager is stating it is in your best interest not staying there anymore like we discussed. This is in a text message, so it's acknowledging that they both had this discussion about him not staying.
best
So I
interest.
don't think it was written down based on.
Yeah, it's a
Best-
conversation.
Best
that
interest in not staying there.
Two very different.
Different.
We're
Context.
disagreeing. You're
Especially in the text.
Yeah, I think you're telling us that the conversation happened. We're not disagreeing
not
that the
disagreeing
conversation
that.
happened. We're saying that we can't determine, based on the evidence of record we have in front of us, that he was told you cannot come back here, and he acknowledged that that's what he heard and understood, and that he then violated that.
Well, all of that was verbal, so it wouldn't be in a writing. None of what you stated would be in a writing, but it's in the text message alludes to the conversation that they had.
We know that the conversation happened, but the conversation you're saying happened, and what we are saying we would need to be okay with this, they're not the same.
So what I'm saying is what you're asking for then is this. There's no writing. This is not in a document. It was a verbal conversation. It's not in a written document.
Okay, well, I can think of at least one thing that I would like to see. Some information about when the hotline informed general manager about the complaint. So when the office goes back, when we take a vote and if we decide that the office needs to go back, that is one more thing we can ask them to provide. And if they can't provide it, they can't provide it.
So if you all want to put a motion and we can get the exact verbiage of what you all are.
Yeah. Is there anything else that people are thinking about or want to get on the table about this case before we move forward?
I just wanted to know the timing of when the complaint was filed and when he was fired.
It says June 11th is when the complaint was filed, and then June 17th was when the termination occurred.
June 11th was when the original complaint was filed, the against the hotel. Is that in here?
So on page 3, under complainant rebuttal and interview. On June 11th, 2022, complainant emailed the Hilton brand complaining of discrimination.
Thank you. Thank you. Yeah, got it.
And I know we talked about this,
Yeah.
but is it possible to get a copy? Normally, when someone is hired to a position, I know I had to sign a code of conduct or code of ethics, and is there such a document out there that we could see that would specifically state the perks of this particular job?
So,
Yeah, the code of conduct for this particular policy about an employee staying at another property is
And
in the writing. You have a physical.
I would like to see that, to see about the belligerent and what, what the circumstances are.
Yeah.
And how that can be terminated.
To my understanding, correct me if I'm wrong, Mr. Mark, they would have to come to the office to do that, or how would that?
I mean, we could probably scan in a copy of that and send it to them at this point. Or, I mean, what we used to do in the past, just so you know, we used to bring the whole investigative notebook to these meetings so people could look through it at that time. Or you're always invited before you come to these meetings to go to the OEI office and read all the notes by the investigator. We keep it in a big notebook. The only reason we don't do that prior is because it is exempt from public records until this investigation is wrapped up and you vote. But you definitely have a right to see all that. But we could provide that to you. Yes.
Thank you. Anything else? All right, board, I think we're now ready to vote. Remember that we may only vote and consider the evidence of record. Equal Opportunity Director has determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. You should vote aye if you agree that there is no reasonable cause to believe that a discriminatory practice has occurred, or you should vote nay if you believe that further investigation is deemed necessary. The board shall specify the areas of further investigation if, by a 3/4 majority vote, further investigation is deemed necessary. Can I have a motion?
I move that this board requests a further investigation.
All right, can I get a,
Oh, do we have this?
yeah, let's do that vote first and then we'll specify.
Okay, perfect.
So there is a vote to reject the current standing, the current ruling, and ask the office to complete further investigation. Do I have a second?
Second.
Or is it to reject or to table a decision on the?
Table.
No, yeah.
Table. All right, so seconded, all in favor?
What you need to specify the exact,
Specify it
I have
now.
down that you want the timing of the hotline call, whether it was reported back to the general manager, you want a copy of the code of conduct, anything else?
That's it. Code of conduct, hotline phone call. We did discuss one more thing.
You discussed the
Oh.
conversation that was being
Yes.
had.
Can you ask the general manager if it is in writing anywhere that, written and signed, agreed upon, that trespassed?
Yes.
Yeah, that the defendant was not allowed to return to that
That's
location.
That
not
was
a
it.
trespass, is he? Did he ever claim he was trespassed? I'm sorry, I'm legal, and
Yeah.
trespass to me means a real specific thing. So was it a trespass that did we ever say he was
No.
trespassed?
He just couldn't
No,
use the
there was no
discount.
trespass.
It was-
A right to vote.
He was
It was
just
more
told
of-
not to come.
Right, if there was, but if it had, the question was if there was anything in writing to him
About-
saying,
Yeah.
you can't be here.
Yes.
Not so much the official trespass. in
Yes,
court.
trespass as, sorry.
More of a internal memo
Right.
from one supervisor to an employee saying you cannot.
So those are our three things. Yep. And so, all in favor of remanding this for further investigation with those three things in mind?
Aye.
Aye. The board, in its discretion, has by a 3/4 majority vote ordered further investigation of the three things we just mentioned.
The board, in its discretion, has by a 3/4 majority vote ordered further investigation of the timing of the complainant's call to the hotline, the respondent's hotline, and whether the general manager was made aware of this call, and if so, when was he made aware? Also, if there is a written document establishing between the respondent and the complainant that the complainant could not return back to the Hampton Inn or the other property. Also, a copy of the policy, the code of conduct policy that's involved in this particular case. The Equal Opportunity Director shall present the results of that further investigation to the board in a written report within 10 days, and the board shall act upon it within 20 days. This concludes today's business as it relates to complaint of discrimination VO-E 2022-32.
All right, thank you. We now move from new business into public comment. Is there anyone in the room or on Zoom who is not a member of the board who would like to speak? All right, seeing none, we move from public comment to member comment. We have a new member of the board. Hi there.
Hi.
Would you like to do introductions?
Yes. I'd like to know, I'm Christina Palacio, and I'm really very happy and honored to be here, and really looking forward to working with all of you on this. It's already clear to me that everybody takes this really seriously, and that it's very exciting for me to, and reaffirming for me to know.
Thank you. So I am Quinn Forbes, serving as pro temp today. I've been on the board for about a year. Been living in Gainesville for my second time since 2020.
No?
I'm Jonathan Stevens. I am a member. I joined about 2 months ago, or I was officially active 2 to 3 months ago, so I'm excited to be here and to help out.
Great.
I'm Joanna Anderson. I've been here about the same time, just I've had a period of illness, so I haven't been here.
I'm glad
Past
you're
couple, getting there, and, but I'm here. Nice to meet you all. Welcome.
Thank you.
Oh, you do too?
Oh, yeah,
Oh.
please.
My name is Innocent Moya. I'm a compliance investigator. So I've been with the city for about almost 3 years.
And I'm the city attorney, well, I'm the labor and employment attorney, the HRB attorney for the city of Gainesville, so.
And I'm Zuzu Kukwale, met
We
yesterday.
met yesterday.
I'm the interim compliance manager. I've been with the office for about 7 months.
Thank you all. Now we move to introductions. Are there any other member comments?
I guess my only comment I would bring up is, I think that I would, obviously, I know that's public records, exempt until obviously we approve it, but if there's any way that you could just have the notes on hand just to refer to them, that would be way helpful, just because there was just a lot of gray area with, whether or not there was a substantiated, please do not return or not, and I think that if you had those notes, it would have been effective. Nothing against y'all, but I think if you guys can, that would help us out and leave us less confused.
Yeah, I would find it helpful to have that, I think.
And so, just kind of for clarification purposes, Ms. Gray actually spoke to the witnesses. So any of the information that I have is from the notes. And pretty much the gist of the notes is in the report.
Okay.
So any other kind of conversations that's not in the notes in the reports, I can't account for that.
Okay, so.
So that's kind of just from my perspective.
Are there any other member comments? All right, so as a reminder, our next meeting date is scheduled for May 17th, 2023. We should be getting an email around the 1st of May to make sure that we can have a quorum, and if there isn't a quorum established on May 17th, we'll look to reschedule the May 17th meeting date. With all that said, it might be time to adjourn this meeting if there's a motion to do so.
I'm going to adjourn this meeting.
Is there a second?
I second.
All in favor?
Aye.
Aye.
All opposed? All right, the meeting is hereby adjourned. Thank you.